Hello and welcome to The Farm. On the show this week,
2 decades of coal allocations lack consistency, transparency, objectivity and merit and are illegal, says the Supreme Court. But what about the consequences? 14 car companies and a 2,500 crore rupee fine. How a CCI order will change the auto spare part industry.
our top story this week, coal is king and paramount lord of industry. A judgment that starts on such a note promises nothing less than high drama. And the Supreme Court did not disappoint in its landmark judgment this week. Over 163 pages, it has documented how, for over 2 decades, successive central governments have allocated 218 coal blocks in violation of law, policy and the Constitution. And it's a long list of violations.
The Supreme Court found that contrary to law, the centre gave states no say when selecting companies for coal block allocations. The screening committee had no objective criteria for selection, nor did it do any evaluation of applicants. Worse still, screening committee meeting minutes have no information on why a particular company was allocated a block. The law did not permit allocations to states or state PSUs, joint ventures with ineligible companies or consortiums, and yet allocations to such entities were made. In many cases, selected companies were neither recommended by the state government, nor the administrative ministry, nor the CEA. In other cases, recommended companies did not get any allocations. Certain blocks with coal reserves on the higher side were recommended to companies with lower requirement. And contrary to the law, most companies that were allocated coal blocks did not have any steel, power or cement plants at the time of allocation. In the Supreme Court's words, the entire allocation of coal blocks suffers from the vice of arbitrariness and legal flaws. There was no fair and transparent procedure, all resulting in unfair distribution of the national wealth. Common good and public interest have thus suffered heavily. Hence, the allocation of coal blocks based on the recommendations made in all the 36 meetings of the screening committee is illegal.
But the hard-hitting judgment stopped short of detailing consequences. It said that a final determination of the consequences of these illegalities requires further hearings. Those hearings will begin next week. So today, we preview the arguments that will take place then and the possible outcomes.
For Supreme Court advocate Prashant Bhushan, this is the second big victory after the 2G decision in 2012. In that judgment, the Supreme Court cancelled 122 2G telecom licenses on grounds of illegality. This time, the Supreme Court has not ordered a deallocation of coal blocks, at least not yet. But Bhushan says that's a logical consequence of the illegality.
These mines or these lessees, leases essentially stand deallocated. The only question for the court to consider now is what would be the transitory provisions as to how the transition would be made to fresh lessees. How soon do these people have to clear out with their mining equipment or whatever equipment they have?
Unless something is brazenly unconstitutional, every illegality or irregularity, every arbitrary action does not necessarily lead the court to invalidate, where invalidation of an individual action will be more productive of public mischief or cause public injury greater than public good. That's a well-established principle. Some of us who have been critical of the 2G judgment have criticized it on this score. The baby went out of the bathwater. Here the court has very carefully kept that issue open.
There are two things. Prashant is right that the natural corollary is that everything having been declared to be arbitrary, illegal and unfair, everything must go. So all allocations from 1993 to 2012 cannot really survive in the eye of law. But Mr. Salve has a point the judges have really not expressly said that there is, deallocations which we are ordering. They have proposed to do so. Now, many a times judges adopt this kind of a approach in matters because they might want to mold the relief.
If there is a full-scale deallocation, it creates a lot of complication because, if you look at many of these projects are, for power plants which are in the hinterland, Western Orissa, Chhattisgarh, Jharkhand. So it's not that simple to say that they will replace this coal with imported coal, because the whole coal importing infrastructure is simply not there and the economics will not work out. The boiler designs were for certain kind of coal which was available in India, which is not going to be the same if you import the same coal from Indonesia. So apart from the economic consideration, there are all these practical aspects where a blanket deallocation will create problems for the economy.
This argument that these people will be unfairly hit, etc., this is a bogus argument. These people have made unfair gains at the cost of the nation, at the cost of the people of this country, and they are now crying wolf.
So it does seem that Mr. Bhushan is going to argue in favour of deallocations. Will he succeed, or will the Supreme Court consider other options? For instance, regularising those allocations where mines are operational or where work on the end-use plant has begun, and levying a monetary penalty or disgorgement of gains.
Molding of relief in exercise of powers under the Article 32 or 226 is an extremely well accepted principle, and judges have been doing it in large number of cases. For example, unauthorized constructions, and as you rightly said, judges impose some kind of a penalty and allow people to carry on with their lives. So that's something which judges have power to do so. Judges have done it in the past, and judges perhaps would take that approach, to my mind, because if they become too harsh, it would not really be in the larger national interest, although personally I feel that everybody should be deallocated. But that's a different issue. I don't think the court might take such a view.
While there is rank arbitrariness, there may be beneficiaries of arbitrariness, there have been victims of arbitrariness. Some people have applied for coal, had an excellent case for grant of coal, but were given a fraction of what they need. Now, it will add insult to injury if you cancel even what they have got. Secondly, we have to be alive to certain realities. If somebody has been granted a coal mine, maybe there was a better competing interest. Nobody has raised the issue so far. That coal mine has been operationalized, investments have been made, third-party rights have been created. If life has gone ahead, it may lead to a completely different set of consequences.
Any decision to regularise some of the coal block allocations might need the Supreme Court to do a case-by-case scrutiny, because it's not just the 30 operational mines that might need saving.
Only 30 blocks with 40 million ton is operating, but what we were expecting is in next 18 to 24 months, the country would have received something like 100-150 million tons of coal from these sources of captive coal blocks. So, Honorable Court would probably look at also those cases where the mine has received all the approvals and about to start production. Also, a very important consideration would be what is the status of the user industry. If the power plant is up and running and having a tapering linkage from Coal India, expecting that this coal will come and that will replace the linkage from Coal India, or there is a steel project or whatever, I think that also is a big consideration, because billions of dollars have been invested in the user industries.
A case-by-case scrutiny to determine which allocations need regularization and which blocks must be deallocated could also be time-consuming.
I won't be surprised if judges, lay down some kind of guidelines and constitute a committee under its direct supervision to go into this and take final call on each of the applicants. I would be very surprised if court were to leave it to the government in the circumstances where it has found that successive governments have acted completely illegally in an arbitrary and non-transparent fashion for almost over 2.5 decades.
I think the court would be relieved if the government can have a hard look at this judgment and come up with a proposal of how you can categorize different classes of mines, those where there has been arbitrariness but innocent arbitrariness, where CBI has not found it appropriate to investigate, those where there has been arbitrariness of a kind which is not corrupt but where there is downstream effect, mines have been activated. It may find that there are cases of arbitrariness where nothing has happened so far, no problem if you cancel it. There are cases where LOAs have been traded, no problem if you cancel it, and so on. So if the government can assist the court in a categorization, it might in fact even obviate, and if the government is honest and does an honest job, it might even obviate the need for a committee.
These are not really issues for the court to decide, because these are matters for the government to decide. I mean, the court has decided what it needed to decide. The only thing left for the court to determine is how soon do these people who are already mining there, how soon do they have to clear out, and whether they would be entitled to take away with them coal that they have already mined till now. To my mind, these are the only two issues for the court to decide. Thereafter, it is for the government to decide what needs to be done, whether they need to hand over these leases to Coal India immediately, for Coal India to resume the mining operations there wherever mining has already started. As I said, mining has already started in a minuscule fraction of those who were given these allocations. So one option for the government would be to hand them over to Coal India or some such public sector corporation. Another alternative option would be to immediately auction these leases and then hand them over to the highest bidder and ask the original people that if they want to match the bid of the highest bidder, they can, they would be given the right of first refusal. Otherwise, it will be given to the highest bidder.
There's no denying that a large-scale deallocation will hurt dozens of companies, hundreds of thousands of investors and the entire economy. But then, regularization is also accompanied with moral hazard. We'll know which way the Supreme Court rules in the days to come. Unfortunately, in this entire conversation, it does seem that the successive governments responsible for these illegal allocations will escape unhurt.
That's true, and I wouldn't be surprised if the petitioners before the Supreme Court might bring a second action to take action against the concerned government officials and the politicians. And frankly, I would definitely agree with you that Supreme Court should not have fallen short of indicting all such officers and ordering CBI investigation and prosecutions, because this is a large scale fraud which has been committed on the nation.
The absolutely final word on this is yet to be said, because a criminal investigation by the CBI and the Enforcement Directorate is currently underway. On that note, we're going to take a quick break on the firm. When we come back,
14 car companies and a 2,500 crore rupee fine. How a CCI order will change the auto spare part industry.